Hello, my name is Michael Tessaro and I prepared this cheat sheet for November 2024. As you can probably see, if you watch these things regularly, I am catching up. So I'm only 2 months behind. I'll be intending to do the December one in the next week or so I'll be totally caught up and hopefully get January out in early February. So a bit of background about myself. I'm a competition and consumer lawyer and I've been running my own practice as sales legal consulting for about 18 years now. I help companies, individuals, competition and consumer law matters. I also do a bit of consulting work for various legal publishers on competition and consumer law issues, and part-time member of NCAT, which is good fun, and also gives me an opportunity to actually apply consumer law in practical settings, which I enjoy doing that very much. Prior to that, I worked at the ACCC for 15 years in a variety of roles. I guess the two main roles of relevance is I was Director of Enforcement and Director in charge of the City Mergers and Asset Sales branch. Now, this month, there isn't actually any ACCC court action, so I've decided to look at a couple of High Court cases very quickly. A lot of enforcement action, a warning was issued, a few mergers, some law reform, authorisations, and some inquiries and consultations. Now, the two court cases that occurred in November 2024, which are relevant to the ACCC and relevant to consumer guarantees in particular, was Williams and Toyota Motor Corporation and Capic Ford Motor Company. And they both involve the consumer guarantee provisions of the ACL, and they both handed down the same day. And the interesting thing is Williams is probably the main judgment, and Capic sort of relies on some of the things there. But it's really important, these two cases, because I think a couple of things. Consumer guarantee laws are very effective laws, but there's still a lot of doubt over the way the damages component works. So obviously, the breach of consumer guarantee, a consumer often has a right, if it's a major failure, to seek a full refund or replacement or repair. But what's more problematic, it seems, is how to calculate the damages arising, consequential losses arising from breach of consumer guarantees. And I think it's fair to say the federal court's been messing it up a bit. Not maybe so much the first instance judges, ironically, it's been more the appeal court judges. A full bench has been, I think, making it overly complicated. Like, it's very straightforward, simple legislation, but I think they've been introducing a level of complexity, which fortunately the High Court came in and has clarified. So the first case basically was Williams and Toyota Motor Corporation. It's a class action and effectively seeking a lot of damages out of Toyota for a particular thing they introduced to their cars to try and reduce emissions, which fortunately didn't work very well initially, and they fixed it up. Now, the High Court allowed the appeal by Williams parties and dismissed the appeal from Toyota, so both parties appealed. And effectively, the court held that the assessment of damages made under Section 2721A is the amount by which the value of the goods is reduced at the time of supply to the consumer as a result of the failure to comply with the guarantee of acceptable quality. So I guess the thing is, when do you assess the losses that have been incurred or suffered by a consumer under the consumer guarantee consequential loss provisions? And it's quite simple, the date of supply. So I guess what the full federal court was doing was bringing in subsequent events to the supply and factoring them in and trying to adjust the amount being paid to the consumer by those subsequent events, mainly because there was a fix available to the particular problem laid out by Toyota. But it just introduces such a level of complexity, looking at all these additional factors and working out when was the fix available, how soon to when the consumer may have disposed of the car was the fix available, things like that. So I guess the High Court just said, hey, just look at when the product's sold. That's the date of supply, is a date when you assess these factors. Now, they say also the assessment is undertaken with having regard to what is known as what is known at the time of trial about the state and condition of the goods at the time of supply, which includes the effectiveness, cost, inconvenience, and timing of any repair of a defect of the goods. So that's something that's relevant, I guess, that if the goods can be repaired, you look at that, you factor that in. But you are looking at the condition of the goods as they, I guess, leave the power, possession, and control of the supplier and enter into the consumer's possession. As neither primary judge of the full court assessed damages payable under the particular provision in accordance with the way the High Court believes the law should be worked out, the matter's been remitted to the primary judge to undertake the task in accordance with the High Court's reasons. So this is welcome clarification of the law, but also a simplification of the law. If the full federal court decisions had stood, then the task of trying to calculate the consequential loss would be much more complicated. Now, CAPIC, as it says at the beginning there, the High Court held that, given its decision of Williams, overturning various parts of the full court's reasoning Toyota, that means that CAPIC appeal also has to be allowed. So consistently with Williams, the court held that assessing damages under the relevant consumer guarantee provision and the timing of the repair of the defect is attributed to the hypothetical reasonable consumer with full knowledge of the state and condition of the goods at the time of supply. So the key thing is you're looking at the time of supply. There's also some clarification there. The appellant's or the consumer's use of the vehicle would only be relevant to the extent that it might bear upon the assessment of what a hypothetical reasonable consumer would, at the time of supply, have expected the vehicle's likely performance to have been prior to any repair. So they're focusing very much on the time of supply. That's the key date to look at. And then, as you see there, as neither the primary judge or the full court assessed the damages in the correct way, then it has to be sent back to be reconsidered in the light of this judgment. And I think the focus of the full federal court was largely on the risk of overcompensation. It took probably a less consumer-friendly approach to the way this legislation operates, which is problematic because this is very, very consumer-friendly legislation. It gives consumers a right in a major failure situation to demand a full refund, but also to recover consequential losses. So, I don't know, the full federal court was making it introducing a number of hurdles and complexity which the High Court overruled. Another case that occurred in November, that I went to watch, and I was helping a bit in this case, was a Delta Automation appeal. They appealed the finding that they'd engaged in an attempt to arrange a price fix, and it was heard in the full federal court. It was Wigney, Abraham, and Halley, and Delta was represented by Ruth Higgins, and she did a very good job. One thing that was a bit concerning about the way the judges were speaking is two judges were, challenged about the technicalities of the law and all the rest of it, and they responded by saying, "Isn't it the gist?" And when I heard the word gist, it just hit me, it reminded me of the castle and the reference to the vibe, Is there a big difference between the gist and the vibe? I don't know. There seems to be a bit of similarity. That's a bit of a concern in relation to provisions of the Competition Consumer Act, which introduced very large penalties on the civil basis and on the criminal basis, potential imprisonment. And what the courts are looking at is the gist of the conduct. I don't think that's right. I think they have to take a more technical and strict view given the seriousness of the penalties. We'll wait and see what happens in the appeal. I guess it'll probably come down early this year, and we'll see what happens. Now, enforcement, there was a lot of activity. The first was Getty Images, and the ACCC resolved this. Interestingly, it didn't appear to have taken any really serious enforcement action. It didn't sue them, obviously. It didn't get 87B undertaking or even issue them an infringement notice. Rather, it got an agreement for them to refund $78,000 to 200 customers after imposing charges for cancellation of iStock subscriptions, which apparently were greater than those outlined in the terms and conditions. And so you can see there between November 23 and February 24, Getty Images may have misled customers by stating on its online iStock terms and conditions that cancelling a subscription after a 1 month free trial period would only incur administrative charge. However, that charge amounted to 50% of the remaining cost of the customer's annual subscription. So I guess people were led to believe that they'd pay a very small amount. And when they say a 1 month free trial period, well, there shouldn't really be any charge at all. But the ACCC here didn't get any formal remedies, really. It effectively got an agreement from Getty Images to refund this money without any other sanctions, which is a bit surprising. The ACCC also identified concerns about statements on the iStock website, which listed a monthly price of annual subscription without stating the total price. So that's also a breach of the law. You've got to state the full price if you know what it is. So I think Getty Images, got away pretty light here. I think there might be a few local players who might be thinking, how did Getty Images dodge this bullet, given other companies have been done probably for doing the same stuff. Magnamail, that's looks like a pretty big, mean case. The ACCC took proceedings against Magnamail for allegedly making false and misleading statements in relation to pre-draw promotions. And I guess this is an interesting case because Magnamail is a subsidiary of Direct Group, which is a very large company, I understand. And they've alleged that Direct Group is not only concerned with the conduct. And here you can see the conduct, and I've been seeing these particular ads for years and years and years. So first time any action has been taken against it. But between May 22 and July 23, there were 12 promotions by Magnamail making misleading statements about if consumers ordered products from its mail order catalogues, they had a right to claim or are eligible for these big prizes, 10,000, 20,000, 25,000, and other major prizes. Now, the interesting thing here is, however, the prizes had already been drawn, and at the time, no one except a small number of pre-draw winners had a right to claim were eligible for qualified for a major prize. Now, that seems pretty blatant and bordering on fraud. If it's already been awarded, then nobody's actually going to get anything out of it. Now, the statements they made, you have definitely won. Congratulations, you've won. $25,000 cash on hold. Congratulations. This means you're qualified for a prize. So very blatant misrepresentation if you think about it. Now, with respect to these scratch card promotions, ACCC alleges the scratch cards issued to every consumer contained a number and they were identical, such as scratching to reveal the lucky number did not actually increase the likelihood that the consumer won a major prize. So this is a very, very problematic conduct. And here the big ads, I reckon I've seen these a few times for many, many years. You definitely won one of these prizes if yours. Like, it's very clear, unambiguous representation to consumers and totally false. Now, if I'm Magnamail, I'd settle this straight away if I could, but the question here is, it's so blatant, you'd imagine there'd be a very large fine imposed. Here's some more 24-hour alert. You have won. Congratulations. I reckon I was getting these sort of letters in the mail 30 years ago. So obviously it's been going on for a long time. First time ACCC or any, as far as I'm aware, any consumer regulator's taken action. Koala Living, I can't say too much about this because I'm actually doing a bit of work for them. I'm helping them with independent review of the compliance program later in the year. But Koala and Tree Proprietary Limited, trading as Koala Living, has paid penalties, infringement notice, 56,340 with alleged false and misleading statements about consumers' rights and remedies. And so there's a couple of companies called Koala. There's Koala Living and there's Koala Sleep, I think. So this is probably the smaller of the two. And they should be concerned that Koala had wrongly stated that consumers could only get a return under the consumer guarantee provisions if they, the problem with the product and they sought the refund within 72 hours or the period of the manufacturer's warranty applied. So, and furthermore, Koala Living could choose a type of remedy for minor and major faults. So there's a few issues there. Alleged as well, Koala Living wrongly informed consumers delivery charges were not refundable, when in fact consumers, if they're exercising a consumer guarantee right, have the legal right to recover those as well. So I won't say any more because they're a current client, but that was resolved with infringement notices, an ACCC undertaking, and they've got to implement a compliance program, which I'll be checking out, making sure that it complies with the legal requirements. Webjet, another biggish case. ACCC commenced proceedings against Webjet in the federal court, alleging that they'd made false and misleading representation to consumers about flight prices and bookings. And here you've got the ACCC alleging that it made statements in apps, marketing, email, social media, and on its website. So it's 4 different advertising media about the minimum price of airfares, which omitted compulsory fees charged by Webjet. So thinking back to Getty Images here, didn't say the full price. These guys are getting sued. Getty Images got off pretty scot-free. But anyway, the statements included flights from X when the price quoted excluded Webjet's compulsory Webjet servicing fee and booking price guarantee fee, which ranged from $35 to $55 per booking. So these are prices that Webjet knew, and when you're saying from a particular amount, you can't leave off these amounts because you know what they are. So should have been from whatever the amount was plus these amounts, probably to be safe, probably plus $54.90. So they were made for a fairly long period of time, 2018 to 2023, so it's a lot of conduct. Webjet later allegedly sought additional payments from consumers to complete the booking or offer the consumer a refund for the flight despite having earlier confirmed the booking. So when they get the money, they said you pay more or you lose your booking. So not great conduct. Here's one of the ads, London on sale, and they've got flights from $13.98. Now that should have included the compulsory fees, so you really couldn't get it for $13.98. It had to be $13.98 plus whatever, $40 or $55. Here's a warning issued. NDIS providers put on notice. This was a funny one where the ACCC got given this sort of key role in managing the NDIS investigations, making sure everybody's doing the right thing. They're sort of in charge of it all. And they issued this big warning 13th of November 2024 saying, watch out if you're an NDIS provider. They're concerned about false representations regarding access to the NDIS. And they gave a couple of examples of conduct. Businesses continue to advertise goods or services that appear on the list of ineligible product supports in a way that suggests NDIS funding can be used to purchase them. So I guess misrepresenting what products can be bought through NDIS support. And then there are no categories of goods or services which are automatically NDIS approved or funded. So that's the thing that you go to the NDIS provider, you work out a program, it gets approved by the NDIS. So to say that there are particular products, that the goods or services that are approved is misleading. And also you can't say that particular providers have any particular approvals or sponsorship. So here it's interesting they put this warning out. I think it's a bit of a spoiler that in December they do actually take action against the first NDIS provider. And there's going to be a bit of action in this area, I think. I wonder if the ACCC wants to do this work or they were dragged into it kicking and screaming. That's what happened in relation to VAT providers. Understand the vocational educational training providers. They didn't really want to get to that, but they ended up doing a pretty good job there, running a lot of cases. Now, the big law reform was the passage of the mergers law through Parliament. It went through very quickly. I think furious agreement on all sides of politics. There was some suggestion by the Libs and the Nationals that maybe should be a bit stronger in terms of various areas, but it's a good reform, I think. It was passed on 28th November 2024. Interestingly, it comes into effect on the 1st of January 26, but people can start using it on a voluntary basis from the 1st of July 2025. The strange provision when you think about it that a law is actually becoming effective from a particular date, but if you want to use it before that date, you can. So I don't think I've seen that before. It provides ACCC with better tools to deal with serial acquisitions. This is what the ACCC said in the press release. Obviously, it's a mandatory system, which is good. Provides for greater transparency. That's not just in the processes, but also in the reporting by the ACCC. Creates a more efficient and faster process, particularly for non-contentious mergers. I think that's right. I think it will be quicker. The thing is, there's a lot of time wasting nowadays by different merger parties, so they won't be able to get away with that anymore. ACCC's always been super fast, I reckon, compared to overseas jurisdictions, so that's going to get better. And allows the Treasury to designate certain high-risk sectors and impose specific notification thresholds for those sectors. So it's a bit of a call-in power, not to call in a particular merger, but to say, well, there's some activity in this particular market which doesn't hit the thresholds, and I want the ACCC to look at it. So that sounds like a call-in power to me, but it's a call-in power by another name. So in the mergers area, the couple mergers, Sanitarium and Vitabrits. This is interesting because I always thought that Sanitarium, they make the Weet-Bix brand, and the Vitabrits are sort of pretty direct competitors when you think about it. But I think I think we'd probably say the Vitabrits are a pretty weak uh, competitor in the market, and that might be the reason why ACCC let it through. So ACCC decided not to oppose it, and obviously Sanitarium is the leader with Weet-Bix, and then you've got Nestle, which does a Vitabrits. And the ACCC, after its market inquiries, found that people don't switch between the two. So that was interesting. And they also concluded that Vitabrits is likely to be a strong competitive constraint on Weet-Bix in the absence of the proposed acquisition. So Vitabrits is a bit of a failing product by the sound of it. And the interesting thing is Vitabrits is actually manufactured by Sanitarium under some toll manufacturing agreement, which I was unaware of. And I wonder if the ACCC was unaware of that, because you really shouldn't be getting a major competitor to manufacture your product without approval. That could be a breach. Anyway, I don't think the ACCC cares too much about that aspect of it. A big merger that I talked about last month, and which I said last month, I've been telling all these merchant bankers who want to get a bit of advice on these mergers that this is going to go through, and sure enough, it went through. ACCC decided not to oppose the merger after accepting a court enforceable undertaking from Sigma, which is sort of a bit strange because it's a reverse takeover, and the people wearing the pants in that transaction at Chemist Warehouse. The proposed merger is unlikely to substantially lessen competition nationally or locally because other pharmacies, not pharmacy retailers, will continue to compete to the same extent they compete now. Effectively, it's really not a horizontal merger when you think about it. It's probably a vertical merger. So I think that's right. It wouldn't affect retail competition. Consumers value different aspects of Sigma and Chemist Warehouse banner pharmacies offerings. So I guess Chemist Warehouse, big range, low prices. I guess Sigma's banner groups probably have less range, but maybe more personalised service. It's a little bit hard to get personalised service in a Chemist Warehouse. It's so usually so busy and crowded. Importantly, customers will continue to have choice between smaller format stores offering personalised services and Chemist Warehouse's offering. Combined Sigma Chemist Warehouse are likely to influence Sigma banner pharmacies to the same extent Chemist Warehouse influences its current franchisees. So that's the thing. There really was never any issue with this merger. A lot of people were making a lot of noise about it, but it was really all a bit of fake news. As I said last time, it was I was going to be opposed. Sorry, I was going to be approved with maybe a couple undertakings, and sure enough, there were three undertakings. Firstly, there's an undertaking to allow Sigma franchisees who went in their franchise agreements prior to 1st January 2024 to just get out of it and join a different banner group. So they can go to API, which is owned by Wesfarmers, or Symbion, which is still probably the largest group, join them instead, and then not have to basically get their pharmaceuticals from, I guess, a competitor, the Sigma Chemist Warehouse combined entity. Also, Sigma can't place restrictions on the collection, use, and disclosure of confidential data and information from Sigma wholesale customers and franchisees for a period of 3 years. So ring fencing information. And finally, remain a participating pharmaceutical wholesale under the under the Commonwealth Government CSO scheme. So it's through, and it'll be interesting to see how things play out. I think there won't be any competitive detriment. In actual fact, probably improve competition in the market. Now, this is a merger that ACCC had problems about. I didn't even know who Blackstone Group was, and I don't actually know how to pronounce the second company's name, IROM Group. But this is in relation to the provision of phase 1 clinical trial services in Australia. And clearly, it's a very narrow market, but it's a very specialised market. And so, as you can imagine, if two of the major providers, or the two major providers, get together, there could be issues there. Phase 1 clinical trials are an important step in trialling new therapeutic products such as medicine. So volunteers come in, try a drug, and then they get data to work out whether it actually works and all the rest of it. So the ACCC are concerned that the proposed acquisition would be likely to have the effect of substantial competition in the supply of phase 1 clinical trials, mainly because there's not too many companies doing it. Bring the two largest providers in Australia under common ownership, and they have 60% of the market, and they assess it in terms of trial beds in Australia. And then finally, is likely to result in lower service quality and high price to consumers. So I guess the companies which hired these people to do this work, probably large pharmaceutical companies, are going to be charged more. Maybe the consumers who they pay to come and be guinea pigs, maybe they'll get paid less. But you'd think that if they're dealing with pharmaceutical companies, maybe they've got a bit of bargaining power. There are significant timeframes associated with setting up new phase 1 clinical trial units. So obviously the barriers to entry are high. So interesting to see what happens there, whether maybe some divestitures occur. Don't mention any competitors here, so maybe there's not too many other people in the market, but maybe some divestitures get this one through. Then Cleanaway citywide services. Now this is a market with huge barriers to entry on every level. I did a few investigations back at the ACCC, and the barriers are just like classic high barriers to entry. And here the ACCC has concerns about Cleanaway waste management buying out basically the business Citywide Service Solutions, which is the City of Melbourne's current provider of these services, collection services for municipal councils and commercial industrial customers. So they're concerned the proposed acquisition will extend Cleanaway's already strong position in Melbourne, would remove the close competitive tension between Cleanaway and Citywide, and also would expand Cleanaway's waste disposal network. Now, I don't know the details here, but there might be some facilities which Citywide can sell off, or the merge party can sell off to get the merger through. A bit like Bingo when it bought Dial Dump, it was able to sell just one facility, which I am still the independent reviewer or auditor of after how many years, I don't know. It's going to be a lifetime gig, I think, that one. I just keep doing it. But anyway, so maybe they can sell a few assets to get it across the line. I don't know. Then Horizon Flinders Logistics. This one got over the line. So this was opposed by the ACCC on a preliminary basis. And then now the ACCC is not opposing it. And it was Horizon's proposed acquisition of Flinders Logistics. And basically what occurred was the parties agreed to restructure the transaction. So following the ACCC outlining its concerns, the major parties restructured the transaction to exclude the underlease for Berth 29 rail pads from the proposed acquisition, which allowed third parties to load and unload trains themselves. So this takes away a vertical concern that effectively the merged firm could actually interfere with downstream competitors. So under the new transaction, rival rail haulage providers will no longer be required to rely on Horizon to load and unload their trains. They will be able to effectively pay an amount and just use the facility. Flinders Port Holdings, the parent company, will retain control of the rail pad and operate as common user asset in accordance with an access policy to be published. So clearly it's sort of said, we'll take this out of the equation. There won't be any vertical concerns, and there'll be an access regime to get access to the facility. That's a clever way of solving the problem. Obviously, not a key element of the deal, and a good way of getting it through. And the other thing is they just exclude it from the transaction, and that's it, all done. They don't have to have any auditors or looking at the transaction to make sure everything's happening properly. Then the ACCC issued some guidelines, free range labelling. This is quite interesting. It's really just issued in the context of a possible outbreak of the deadly avian influenza H5N1 in Australia. It's basically saying if that occurs, what is the consequence on the free range eggs? Because if that is an avian influenza outbreak, then maybe these chickens aren't allowed to run around outside. So what's going to happen? Are they going to be in trouble for misrepresenting their eggs are free range? So basically what the ACCC has decided is effectively if there is some outbreak and the federal government or even state or territory governments make some order that the chickens have to be housed and can't run around free, then under the guidance, the various egg and poultry meat producers will continue to be able to sell their products with free range labelling for 90 days during declared outbreak, which is, I guess, pretty misleading at the end of the day. But I guess it's just factors outside their control, and I guess that's part of the problems. Changing all their packaging and labelling and all the rest of it. They had to do it instantaneously. It'd be pretty well impossible. Authorisations. I thought this was finished last month. I'm a bit confused, but anyway, the ACCC is seeking views on the proposed price increase. So this is a little reserve services to Australia Post. They're not making any money in this anymore. People don't use these services very much, and so just proposed price increase. And the ACCC seeks some views, expresses a view, but then ultimately it's the minister who determines whether it's all right to go ahead. Now, Virgin and Qatar. There's a proposal for them to get together. And this is interesting. It's interim. It's not a final. And this is really to allow them to get together and see how things work, but also they need approval from other regulators. So the Minister for Transport has to sign off on this too, I think. And I think historically she hasn't been a big fan of Qatar. She sort of prevented them from entering the market on their own. So here Virgin and Qatar are proposing to come into the market together, or they're proposing to work in the market together. And effectively, under the interim authorisation, the two companies agree to commence marketing and selling 28 weekly scheduled return flights between Doha and a few Australian cities. Clearly, there'll be a lot of public benefits arising from that. Like, it's obviously a big centre, Doha, and the claimed public benefits: enhanced products and services, increased capacity between Qatar and each of these places. So there's heaps of public benefit here. It really is a case whether they need to get approval from other authorities, the minister. Now, the inquiries and consultations, the supermarket inquiry was announced a while ago in November. The ACCC made a sort of an unusual decision to conduct public hearings online and live, so people could watch them and see all the evidence. I don't think, well, I didn't do it. It wasn't the most riveting thing for me, but you sort of read a few articles summarising the evidence, and some interesting evidence came out. But it's probably a good thing to make it nice and transparent, give everybody an opportunity to speak. And obviously Aldi, Coles, Woolies all came in and gave evidence in relation to those things, and Metcash as well. So they're being live streamed on the ACCC website, and there'll probably be further public inquiries. ACCC's got a report in February 2025, so they didn't have much time given. I'm doing this in January. They've got a month to get their final report done. It's going to be interesting what they say. Domestic airlines, this wasn't a surprise. Domestic airline competition report, prices have gone up. Rex has exited the market, and Qantas and Virgin put their prices up. Surprise, surprise. So since Rex suspended operations on its services between various metropolitan cities, average airfare on all major routes has increased by 13.3%. And since July 2024, the number of seats on services between metropolitan cities fell by 6%, with the number of domestic passengers travelling on these routes remained relatively stable. So, and I've been travelling a little bit lately, and the flights are chockers. In the past, there'd be a few spare seats. Went to, where'd I go? Ballina the other day on NCAT work, and went to Jetstar, and there were no vacant seats at all. The report found that airfares for best discount economy seats have increased. Oh, well. So people aren't getting the same discounts they got previously. So obviously, it just says a lot about how uncompetitive Australian domestic airline market is. Qantas and Virgin don't compete, and the first opportunity they get to put prices up, they do. Petrol prices, a bit better news. Quarterly petrol monitoring report, average retail prices significantly lower. Lower crude oil and refined petrol prices were the reason for that. Regional retail prices also decreased on average. Diesel prices were lower. And the interesting thing, so this all makes sense, if international prices go down, our prices go down, so that all makes sense. But new hybrid vehicle sales increased 16.7% of new car sales. So a lot of people, you see a lot of electric cars around the moment, but a lot of people are going with the hybrid. They're not totally sold on the electric, and going with the hybrid sales. So that's interesting statistic. Now, commentary, it was a very interesting month, I think. The High Court providing clarification of consumer guarantee law. I think the full federal court's got to get its act together. You've got the primary judges making the right decision, and some full federal court judges just messing it up. You're getting bamboozled by some of the legal counsel who are putting these elaborate submissions to them. But at the end of the day, consumer guarantees law are very simple, straightforward. Consequential losses are very straightforward. And so now a lot of clear guidance and simplification for the lower courts to get this right. NDIS enforcement, as I said, there was a case in December, and I reckon there's going to be quite a bit more. There's unfortunately, a lot of bad conduct in that market, and the ACCC is going to get to the bottom of it. It might end up like the VET providers that's running, 20 cases in this area, but I think if you're an NDIS provider, you've got to get your house in order, because ACCC will catch you. Merger laws being passed, well, that's been pretty record time, I think. no real opposition on either side of politics. I think they're good changes. A lot of people are complaining about them. I think it'll stop a lot of the bad behaviour. Some people are obviously misusing the system. So it'll be interesting to see how many merger parties decide to use a new system in 2025. I don't quite know why you do that, but maybe some people might do that. Similar Chemist Warehouse merger approved, which was no surprise to me, no surprise I think to a few people in the competition area, but it's going to be good for competition. I think the fact that the Pharmacy Guild was against it, you can probably be pretty certain if they're against it, it's probably pro-competitive. And the supermarket public hearings, they were quite interesting when you're reading the short articles that came out about what people said. I think there was some interesting revelations about the way these guys operate. So that's all I have for the month. A good month. I think it wasn't too busy, and I'm almost caught up now. If you've got any questions about anything I've spoken about in this particular presentation, feel free to give me a call or drop me an email. Bye bye.